Case 16A0323, Jack Scott versus the state. Mark Bennett for appellant, Jay Sekulow for appellee.
May proceed when ready.
May it please the court. My name is Mark Bennett, and I represent Jack Scott. Under the First Amendment, all speech is protected unless it falls into a recognized category of unprotected speech. In this case, the government has forbidden speech, including a vast swath of speech that falls into no unprotected category of speech. The United States Supreme Court has never recognized a category of unprotected speech that includes explicit communications to a minor, even with the intent to arouse or gratify the sexual desire of the minor. And that's the speech that is forbidden in this case. It may happen, coincidentally, that some of the speech that this statute forbids is obscene. It may happen, coincidentally, that some of the speech that this statute forbids is enticement, an attempt to get a child to have sex. It may happen, coincidentally, that some of the speech forbidden by this statute is child pornography. These are categories of unprotected speech. But if the speech that is forbidden by this statute falls into one of those categories of unprotected speech, it is mere coincidence. The legislature has defined harmful to minors in Georgia. The definition of harmful to minors follows the United States Supreme Court's definition of harmful to minors from the Ginsburg case. In section 1612.1021 and 1612.100.1, in both of those statutes, the definition of harmful to minors is laid out. The state's argument here is that the speech that is forbidden by 1612.100.2e is harmful to minors. But it's not harmful to minors under the definition of either 1612.102.1, 1612.100.1, or the Ginsburg case. The government argues that, and the amicus, they argue that, well, let's look at the cases that have been prosecuted, and surely cases aren't going to be prosecuted if the speech is something desirable. And there are two flaws with that argument. One flaw is that the US Supreme Court has said that the First Amendment protects us against the government and doesn't leave us at the mercy of noblesse oblige. That is, the courts will not and cannot uphold a statute merely because the government promises to use it responsibly. US v. Stevens is the key to this case. If you read US v. Stevens, you see that the United States Supreme Court, in its recent First Amendment jurisprudence, has not only followed a categorical test, that is, said, okay, here are the categories of speech that is unprotected and speech outside those categories is protected, but has also rejected a balancing test. What the government, the state, excuse me, what the state and the amici propose in this case is essentially a balancing test. They don't use the words balancing test, but they say this speech is harmful to children, and therefore the state may forbid it, may punish it penally. US v. Stevens rejected as startling and dangerous the proposition that such a balancing test might exist. In US v. Stevens, the United States Supreme Court said, the First Amendment itself is a judgment by the people of America that there is speech that the government cannot meddle in, that the government cannot forbid. We're not talking about the sort of speech that we want people to engage in. I will concede that. I will concede that the speech forbidden by the statute is unpleasant, icky, disgusting. I have a teenage child myself, and I would not want people communicating in this way with my teenage child.
In all your talk about this, one question is exactly what speech do you think is prohibited by this statute? Because the way the trial court read it and the state seems to read it, it would cover speech that is transmitted with the intent to arouse or satisfy the sexual desire of the sender or the child recipient. That seems to me a much harder defense for you than if, as I thought you were arguing, that it only covers a contact that happens to discuss matter which then contains a description of material that might arouse.
Sure. I agree with you that it's a much harder defense for me, but I willingly accept the burden of taking up that defense, because even if we read the statute the way that the trial court and the state have read it, which is to apply the intent to the transmission of the message rather than as the rule of the, what do they call it, the rule of the ultimate antecedent or the preceding antecedent, the rule of general statutory construction, that when you have a modifier such as with the intent to do whatever, it applies to the last thing in the list before it. So that, that argument is in my brief. But it's a secondary argument, and it's not key to the argument for why the speech forbidden by the statute is protected and why the statute is unconstitutional. If you look at my brief, I have the section on how the trial court got it wrong, and the first thing I say is that the trial court applied the intent to the content of the communication, and I use the example of the nudie magazine found by the mother, and the mother wants to talk to the child about it. But that's not key to the Stevens-based attack on the statute here. Even if the legislature had written a statute to say a person commits an offense if, with the intent to arouse or satisfy the sexual desire of himself or of the child, he communicates online with the child about, in a narrative way, about something sexually explicit, the statute would still be unconstitutional because that speech falls into no category of unprotected speech. Not only does it not fall into any recognized category of unprotected speech, but to recognize a new category of unprotected speech that included that speech forbidden by this statute would be ahistorical. Until 1918 in Georgia, the age of consent was 10 years old. In 1789 in the United States, when the Constitution was written, when the Free Speech Clause was, before the Bill of, even before the Bill of Rights, the age of consent was generally about 12 years old. It was in 1918, Georgia raised the age of consent to 14 years old. And it was only in 1995 that the state raised the age of consent to 16 years old. So from 1789 until 1791, let's take 1791, the age of consent was, the sources vary, but somewhere around 12 years old. From then until 1995, there was no judgment that it was harmful to a child to sexually arouse the child, because a child could consent to sex, could be married, could be a husband or a wife. So that, and I'm not saying that I think the age of consent should be lowered because of this, because what we're talking about here is a speech case. We're not talking about a conduct case. Nobody quibbles with the state's ability to say, okay, now the age of consent is 10, now it's 14, now it's 16. In Texas, I'm from Texas, it's 17. I understand there are states where it might be younger, it might be older. Nobody would say that the state cannot make that judgment, that there are certain acts with children under a certain age that are impermissible. But the First Amendment is not about the acts. The First Amendment is about the speech. And if the speech, if there's not a historical basis for saying this is the sort of speech that has always been forbidden or has always been forbiddable, then we cannot recognize a new category of unprotected speech that contains, that covers what the state is attempting to forbid here.
And let me ask, to be clear, your argument depends on an overbreadth attack on the facial validity of the statute. You would have, depending on the exact facts of the case, you'd have potentially no ability to raise an as-applied challenge.
Exactly, Your Honor. I don't know what the facts are of this case. When I make an overbreadth challenge, I don't need to know what the facts are of the case. The courts don't need to know what the facts are of the case, because an overbreadth challenge is about the statute as written. There might very well be instances in which the speech that was prosecuted under 1612 100.2e was obscene and so was unprotected. There might be instances in which the speech prosecuted under this statute was child pornography and so was unprotected, or was the solicitation of a child to have sex and so was unprotected. So somebody who had actually communicated with a child attempting to meet with the child for sex could not raise an as-applied challenge to the statute. But that person could also be prosecuted under other Georgia statutes, because the communication with the child with the intent to entice the child or to try to entice the child is a violation of 1612-102. No. I'm sorry, I don't have the statute at my fingertips. The actual attempt to entice is a violation of 1665. The doing of an immoral or indecent act is a violation of 1664. So the transmission of obscene material or material harmful to children is a violation of 1612-103. So that these things that can be forbidden are already forbidden. We are forbidden from providing obscene, that is harmful to children, material to children. And the state and I may have a difference in agreement in terms. I use the US Supreme Court's harmful to children as harmful to children. When I say harmful to children, I'm using the term as a term of art, as the Georgia legislature and the US Supreme Court have used the term. So if a person's communication to a child were harmful to the child, then that person would not have an as-applied defense to the statute, but he still could raise an as-written challenge to the statute. The reason is that an as-written challenge to the statute can be made when the statute forbids a real and substantial amount of protected speech. Our position here is not that the statute defines the speech so that most of it is unprotected and some of it happens to be protected. Our position here is that the statute defines the forbidden speech so that all of the forbidden speech is unprotected, and if it happens to, is protected, and if it happens to be unprotected, that's only coincidental. That's only because, incidentally, the defendant has used obscenity, has sent child pornography, or has tried to entice the child to meet. The amicus's position is that, well, this is grooming. The state disclaims in its brief that they're basing their argument on grooming. That's fine. The amicus suggests that this is about grooming. They talk about sending images. They talk about meeting with children. The state can forbid, and does forbid in other statutes, adults trying to meet with children for sex. But there has to be a cutoff point. There has to be a safe harbor for the First Amendment where people don't have to worry that their speech is going to be misinterpreted as intended to arouse or gratify. Okay, so there's this arouse or gratify element in the statute. Right? It's only a crime if the defendant intends to arouse or satisfy, the sexual desire of himself or of the child. Speech to a child with the intent to arouse or satisfy the sexual desire of the adult or of the child is distasteful at best. It may be grooming, but that doesn't make it unprotected speech. In order to holding the statute unconstitutional, holding that this statute is void, is not an endorsement of the speech that the statute forbids. It's an endorsement of the First Amendment. My argument that this statute is void is not an argument in favor of the speech forbidden by the statute. It's an argument that, okay, even though this speech is repugnant to all of us, it's still protected by the Constitution.
So just again, to be clear, so you would concede that speech can be used to prove an attempt to solicit or an attempt to have the child engage in some other criminal act. There would always be a question of whether the particular speech at question is evidence of that, just like in conspiracy cases. You have to figure out whether the speech had something to do with proving a conspiracy, but the speech alone cannot be the proof of the crime? Or, well, that may not be the
I'm not sure I even understand how you've
I mean, the
rephrased it,
state
Your
can
Honor. I'm sorry.
prohibit grooming speech if, in fact, it can prove that it was grooming speech.
That the speech was engaged in with the intent that the child engage in sexual activity with an adult, in forbidden sexual activity. I don't agree with the state or with the amicus that a child is harmed by being sexually aroused. I was a 15-year-old boy, and I don't believe that I was harmed by being sexually aroused. I spent most of my teenage years trying to be sexually aroused, and with less success to be sexually satisfied. I don't believe that children are harmed by being the subject of adults' own attempts to be aroused or gratified. I think that every woman in America has the experience of being a teenage girl and suddenly noticing that guys are looking at her differently, because men in America look at girls who are not all guys, but I think that Justice Hunstein probably had this experience when she was young, and I think that your wives and your daughters have had the experience, if you talk with them about it, of being objectified by men just because of their bodies. I don't think that people are harmed by that. I don't think it's desirable. I don't think it's something that we have to endorse, but it's not the sort of harm that the First Amendment allows the legislature to forbid. And unless there are any more questions right now, I'd like to reserve the balance of my time for rebuttal.
All right, so,
Thank you.
sure. Sokolow?
Mr. Chief Justice, and may it please the court. Mr. Bennett started his argument by saying obscene speech, child pornography, these are activities that can be prohibited. They're outside the scope of the First Amendment. This court has asked whether the trial court committed error when it denied the appellant's general demur challenging E1 as facially overbroad in violation of the First Amendment. It did not, for the specific reason that Mr. Bennett outlined. To prove overbreadth, Mr. Bennett has to establish that the statute itself is both real and substantial in its reach. It is not. The Georgia legislature, in a carefully crafted statute, criminalizes specific conduct, in this particular case, child exploitive activity, conduct engaged in, for the very specific purpose, the purpose of arousing or satisfying the sexual desire of either the perpetrator or the child. Mr. Bennett said that it doesn't bother him if, in fact, a child is impacted this way. It bothers the state of Georgia. And the state of Georgia has a very carefully crafted statute on that regard.
Let me ask you about the crafting, because
Yes.
while the appellant is willing to try to fight this battle on harmfulness type grounds, the statute itself, the state argued, the trial court found, makes the intent to arouse or satisfy the intent element for the contact. And I find it very difficult to read it that way. It is that is intended to arouse or satisfy clearly modifies, in my view, the description or narrative account that is then contained in the matter that is then involved in the contact.
Correct.
So that, for example, a mother describing that she had read 50 Shades of Grey, which is a narrative account of sexually explicit activity that is intended to arouse the reader, the mother, describing that she had read that book to her child, who's under 16, would violate the statute.
No, it would not. And here's the reason why. The contact itself, you have to read the statute in its entirety. Look at what it prohibits. A person commits the offense when he or she, with the child or someone he knows to be or she knows to be a child, believes to be a child, engages in a computer platform. And then it says, and the contact involves any matter containing explicit verbal descriptions or narrative accounts. That is intended, and then it lists what the acts are, that is intended to arouse or satisfy the sexual desire of either the child or the person. And frankly, Justice Namias
Left out a bunch of words of the statute.
None of which-
Contact
Go ahead.
involves a matter containing descriptions
Right.
that are intended. to, I mean, you can read these things backward. You can read them, there needs to be an intent to arouse that is a description or account that is contained in a matter that involves a contact to a child. If you do it that way, it just doesn't, the intent just doesn't apply directly to the contact.
I think the intent, when you read the statute in the entirety, including the language, the explicit verbal description, no matter which way this statute is construed, where you plug in the intent element, the fact of the matter is this is an overbreadth challenge. This court, of course, could adopt a narrowing construction if the intent issue is of concern to the court. But to strike the statute down as facially overbroad, in our view, is wrong as a matter of law, and frankly, the reliance that the appellants place on the case of Ex parte Lo, which is the Texas Court of Criminal Appeals, is very different. In that particular case, talking about the arousal and gratification section under the Texas law, it applied to any person. So not just the child, not just the perpetrator. It applied to any person. The definition of sexual conduct said related to, in any way related to sexual conduct. It's very different than Georgia statute, which actually mirrors closer to the Ferber definitions. So wherever you place the intent in the statute, the appellant's argument is that it is substantially overbroad, and that makes no sense in light of not only narrowing construction rules, but the plain reading of the statute. Because the fact of the matter is, the reported cases...
What is the narrowing construction? Because narrowing constructions have to be reasonable.
Sure.
They generally involve adding in an intent element where there isn't one. There's clearly an intent element that the contact has to be a purposeful contact.
Of course.
So what would the narrowing construction be?
To save the statute, and I don't think you have to go there. I mean, I don't think the court has to go there. The intent could be placed on the containing explicit verbal descriptions.
Well, it could be if we just ignore grammar and
I don't think so. I don't think so. I think the reality is, if you look at the statute as written, even within the context of your definition, if the court were to adopt the appellant's definition of where the intent places, this court would have to determine that that statute is suffers substantial and real overbreadth. Strong medicine, as the court said. And this provision, this intent provision, that states clearly the intent to arouse or satisfy the sexual desire of either the child or the person, in our view, is very specific. And I need to add two other things. The reference to the age of consent. This statute applies to children under the age of 15 and under. Now, the fact that the age of consent may have been in 1791, the age of 10, is interesting, but irrelevant. In 1791, we did not have an internet. In 1791, we did not have the ability to communicate that we do now.
In 1791, did we have a category of unprotected speech?
Oh, we did.
That was saying sexual things to children?
No, but we had categories of speech, albeit questionable, as to whether you could say things about the government, if you refer back. But the fact is, this is not saying something about children. This is saying something to children.
Right.
To children, very different.
In 1791 or in 1868, did we have a category of speech that said that adults cannot say things to children to sexually arouse them or satisfy the adult?
Well, there's been child delinquency statutes in most states, and I don't know Georgia's history on this, but in most states there's been contributing to child delinquency, certainly since the 1800s, 1900s. But the purpose of this statute was clear. It was to get the technology to catch up with the problem. This is not activity that can be handled by other statutes. This idea that, well, there's other statutes that prohibit this speech or this conduct or this contact, that's not true. This is targeted directly at a situation where an individual has contact with someone they know to be a child or believe to be a child, and that they engage in that contact for very specific reasons. And again, the reliance on ex parte Lo falls on two accounts, as I've already said.
Just to be clear, are you saying there is or is not a historical category of unprotected speech regarding statements, no conduct, statements to children intended to arouse or satisfy the child or the speaker?
I will not say that there's a history of that statute. I would say that child abuse, child pornography. What this court, what the Supreme Court in Ferber said, it may be, and in Ginsburg, what may be deemed obscene as to a child may not necessarily be obscene as to adult. But the court said that obscenity as to the child is, in fact, not protected speech. And I would point the court also to, when we did this in our briefs, there's a whole category of activity that may be protected in one category to adults, but you take, I could even go to Bethel versus Frazier, where there a student gave a speech that had sexual innuendo. The student's parents challenged it, saying that the prohibition was a violation of First Amendment rights, and the Supreme Court said no, because for that audience, that was deemed to be inappropriate. This goes far beyond the scope of what the statute is dealing with here is much different. It's much more targeted. It's much more direct. So the idea that Pacifica is another example. There, George Carlin's 50 dirty words monologue, which may be deemed protected if it was to adults, certainly would be, was not deemed to be protected when it came to children who had access to it. This statute is very specific in its targeting and very direct. Now, in the brief, the appellants rely on Reno and Ashcroft. Ashcroft dealing with the virtual child pornography issue. The court said there was no harm because there was no child involved in the actual act. And later in United States versus Williams, of course, the court pointed out that if it was involving an actual child, in the previous case, they didn't even challenge that. So they acknowledged, Free Speech Coalition acknowledged that when it came to actual children being involved, that in fact, they can be protected. In the virtual porn case, the problem was there was not an actual child. Here there is. The child is the target. You know, Mr. Bennett goes through the list of things he'd like to do as a 15-year-old boy. I'm not sure that I'd like to have that done to my 13-year-old granddaughter. And that goes back to what is the state prohibiting? And again, on a facial challenge, which is what this is, I think that it's misplaced, relying again on whether it's Ex parte Low or Ashcroft, or taking it a step further, and that is the reliance on Reno. And I think reliance on Reno is also misplaced. Why? There was no specific intent requirement in Reno. Now, Justice Namias, you may not like where the specific intent provision ends up in the statute, but in Stevens, in Reno, there was no specific intent as to causing the arousal or gratification of either the child or, in the particular case, the perpetrator. So I think reliance there is misplaced. I also think that, again, I go back to the nature of the challenge here. This is an overbreath case, real and substantial overbreath. Of course, as I said, an error in construction can certainly solve that if that's an issue. We pointed that out in our brief. I would submit, though, that this statute would survive even under Miller. That is not the standard, and the appellants argue Miller in their brief, ignoring Ferber, which said the Miller standards don't apply when it's child pornography. They also rely on Stanley versus Georgia for the proposition that a man's thoughts are his own, which is also what the Texas Court of Criminal Appeals relied on as well. Let me say that that also was rejected by this court in Hunter, which relied on Osborne versus Ohio, which had that even the mere possession of child pornography was actionable, criminal, if it's so put forward by a statute. That is because the harm was much more significant to the child than in the situation with what we called adult, even hardcore pornography or obscenity. This court in Hunter said that the standards don't apply, the protections of Stanley versus Georgia don't apply, and that's where I think, by the way, the Texas court got it wrong as a matter of law, in addition to the clear distinctions in the statute, but I think they got it wrong as a matter of law. In Hunter, this court said that Stanley would not apply because, unlike Stanley, the present case does not involve a man sitting alone in his own house, nor does it involve, again quoting from the court, mere possession of obscene material by the individual in the privacy of his home. Rather, it involves the exhibition of such material to a child and antisocial conduct engaged in by the appellant in connection therewith. Consequently, Stanley is distinguishable and Ginsburg is controlling. The court went on to say, this court said, the state does not rely on paternalistic interests in regulating Osborne's mind. Rather, Ohio has enacted the statute to protect the victims of child pornography. It hopes to destroy a market for the exploitive use of children. And that is precisely what the state of Georgia has done here. And the burden here, or the issue being addressed here, I would say is—
How was child pornography defined in those cases?
Use sexual conduct or sexual contact between minors is usually how it is. That's the general definition of child pornography.
Right.
So Georgia's adoption—
This statute goes far beyond that limited definition of what child pornography or child obscenity would be.
Well, I don't think it goes way— I don't think that's fair. I don't think it goes way beyond. I think that if you look at the language of Ferber and the statute involved there, and Ginsburg for that matter, is very similar. The language is similar. It tracks, of course, a more current medium of communication, which is the internet.
It's not the medium. The medium is tracked by a different provision of this statute. It's the content of the speech. And the definitions that— well, the things you're referring to as child pornography tend to be things that do involve sexual conduct or the solicitation to sexual conduct.
Solicitation is different. That's a different provision.
Right. I understand it's a different provision. It falls into a different unprotected category. The question is, this statute covers descriptions of sexually explicit nudity, sexual conduct, well, particularly sexually explicit nudity, which is defined very broadly in the statute. So unless we're going to also engage in a narrowing construction of that, it seems like we start having to narrow words a lot.
I don't think so. And again, that's where it's not just the definition of the term that's prohibited, but also the intent upon which that was delivered. And I also would point out that the cases, the reported cases of E1, and we pointed this out in our brief, that the Georgia Court of Appeals has dealt with, have said, and this is a summary of the facts, graphic as it is, in each of these cases, defendants believe that they were talking to a child asking, for instance, whether she liked penises, whether she penetrated herself digitally, and demanded that she do so. In other cases, webcams were utilized for the purposes of showing inappropriate sexual acts.
What's the relevance of any of that to an overbreadth challenge? In an overbreadth challenge, part of the danger is we can't rely on prosecutors to exercise their judgment correctly. We have to worry that a prosecutor is going to exercise their judgment incorrectly.
That's correct. But the definition of these terms with the intent requirement in the statute clearly falls within the Ferber-Ginsburg track of statutory construction. I mean, these statutes were not developed out of thin air. If the court were to look at, and I'm sure has, Ferber and Ginsburg, there's very similar language, almost identical actually in parts. Now, the difference is, if you look at the ex parte low case and the concern over overbreadth there, the concern, of course, was that the statute could apply to any person. It wasn't just the individual or the child. Here, again, the scope of this statute, Justice Nimas, is very, very limited. These statutes are utilized when there's not a furnishing of material. These statutes are utilized for interactive, real-time communication. And what this statute, what E1 does, is serve the state of Georgia's compelling governmental interest in eradicating a very serious problem. I use the facts of the cases not to point to prosecutorial discretion. That, of course, is not a defense. I use those cases to point to what the real problem is, and that the language of the statute, if the court goes back and looks at the definitions of sexual conduct, first of all, it's sexually explicit nudity, sexual conduct, sexual excitement, sadomasochistic abuse. Those terms are defined in the statute. They're defined under Georgia criminal law. This court has reviewed some of those statutes before where the general definitions are. And it's far outside, in our view, of a situation where the statute could be challenged as substantially overbroad with real overbreadth. Unless the court has further questions. Thank you.
Thank you. Mr. Bennett, any rebuttal?
Yes, Mr. Chief Justice. Thank you. Thank you, Mr. Sekulow. Suppose that the Georgia legislature were to pass a law saying that it is illegal to criticize the government with the intent to arouse or gratify the sexual desire of a child. Well, we all know that criticizing the government has nothing to do with arousing and gratifying the sexual desire of the child, but according to the state's argument, that would make that content-based restriction on speech valid, because adults are not allowed to arouse or gratify the sexual desire of children. Suppose instead that a Georgia prosecutor wants children in his county only to be taught abstinence-only sex education, and sends a message out to the teachers in the county saying, if you teach children anything other than abstinence-only education, I'm going to construe it as you having an intent to arouse or gratify their sexual desire, and I'm going to prosecute you for it. The problem with the intent element is that it causes people to hedge and trim. People who know that their speech might be construed incorrectly as intended to arouse or gratify are going to avoid that speech, even if the speech is not intended to arouse or gratify. So a parent is going to avoid, and Mr. Sekulow says this is about real time. It's not about real time. This can be in an email. A parent is going to avoid advising his child about, well, counseling his child about sex. Even, don't take your clothes off with a boy in the room. Explicit description, don't take your clothes off of nudity. Sexually explicit nudity doesn't have to be sexually explicit. A parent is going to hedge and trim because of the concern that it could be misinterpreted.
If the intent element is read as you fall back saying it can be read and Mr. Sekulow says it should be read, then that content, counseling your child, unless that was to arouse or gratify yourself or the child, would not be encompassed.
Right. So you're correct that it wouldn't be encompassed, but the problem with a free speech restriction statute is that it chills speech, so that even if a person does not have that intent, he's going to avoid the speech so that he won't be construed as having that intent.
Usually it works the other way. If there's a scienter requirement, we tell people you're safe because the government would have to prove that intent beyond a reasonable doubt to a jury of 12 regular people.
And in the First Amendment context, it's different. If you look at Thomas v. Collins out of the U.S. Supreme Court, it was a contempt case where the court noted that the intent element just makes it more likely that people who don't have the intent will avoid that category of speech. So while ordinarily I would say, hey, that's a great thing to have an intent, in the First Amendment context, it just doesn't help because nobody knows what other people are going to think that we intend to do. Justice Namias, I think you're correct about reading the statute so that the last antecedent rule applies and that the intent only applies to the content at the bottom of that stack of things. The statute is unconstitutional either way. The state has admitted that there is no recognized category of unprotected speech into which this speech falls. And that's the end of the inquiry. This speech does not fall into any category of unprotected speech. Well, it's not quite the end of the inquiry because then we have to ask, might we recognize a historical category of unprotected speech into which it falls? The answer is no. The statute fails. Thank you very much for your time. We pray that you hold the statute unconstitutional, reverse the Court of Appeal, reverse the trial court, and order dismissal of the indictment. Thank you.
Thank you. On behalf of the court, let me thank both sides. Important case, and we appreciate you coming all this distance to help us with it. Be safe as you journey home. Trooper McIntyre.